and welcome to today's presentation Ask a Pro webinar. Today's webinar is the Subro Scoop, Part 2, How to Navigate Securing Recovery on Novel Claims and Subrogation. My name is Tiffani Palmer, and I'm a shareholder here at Wellman. My key role is to oversee the litigation on subrogation cases in Michigan. And that's an array of type of subrogation cases, from auto negligence to property damage, premise liability, product liability, and Michigan no-fault priority scheme disputes. I will actually celebrate my 10-year anniversary, January 2026. I'm excited about that. And I come to Wellman with a unique background. So first, I was actually a claims adjuster at a major insurance carrier. And then after that, I went to law school and started practicing as a plaintiff's attorney after graduating law school. So I always joke that I used to sue insurance carriers. Now I work for them, so I'm on the good side now. But be careful, I still sometimes sue other carriers. But enough about me. Let's meet the stars of this show. So we'll start with Ted Traut, then go to Mike Chapman, and then to Tom Duquette.
Good morning, everyone. My name is Ted Traut. I am the office managing attorney for our Cleveland office here in Cleveland, Ohio, and I'm also the chair of the Subrogation practice group. I've practiced in the subrogation space my entire career, so that's over 25 years now. I started when I was 10 years old, so I was a Doogie Howser. No, seriously. So my role here is I handle subrogation claims in Ohio. I also do some debt collection claims as well. And I also act as in-house counsel for our subrogation collections team and our national attorney network team that handles the subrogation claims. So handled pretty much almost any kind of a subrogation claim you can think about. So I'm happy to be part of the group here, and let's see what we can learn today. Hopefully I learned something too. I usually do.
I'm Mike Chapman. I'm an attorney in the Cincinnati office of Weltman, and I'm admitted in Ohio, Indiana, and Kentucky. And I love doing subrogation. I graduated from Indiana University a long time ago and spent most of my career doing product liability defense work. And I just couldn't be happier to be part of the subrogation group, solving problems and coming up with novel ways to squeeze money out of people.
And I'm Tom Duquette. I've been an attorney here with Wellman for about 2 years now. I come with background in Michigan, no fault first party practice. Like Tiffani, I also used to sue the insurance carriers, and now I'm doing the suing for them.
Great. Well, thank you so much, gentlemen, and I'm excited to go ahead and get started. And with that, let's actually do that. But let's actually get started without having another issue. There we go. Okay. So before we officially get started, I have a few housekeeping matters I just want to go over with you. Because this is an interactive webinar, we do encourage you to type any questions you may have in the subject box, and we'll try to get to as many questions as possible. I do want to let the guests know that all of the questions that we have here were presented by your colleagues, and so we hope to answer as many questions as we possibly can, but if we cannot answer them all, we'll get back to you with additional information. Now, this webinar is planning to go about an hour, so it should not exceed past noon. But if we go over, like I said, we'll end right at noon and we'll give you additional information as needed. If you have any other information you want to share with us, feel free to put it in the box, or if you want us to elaborate on something, feel free to put that in the chat box. Other than that, I think we should just go ahead and get started and dive right in. So we have our first question. As the insurance carrier, am I able to recover out-of-pocket damages for my insured? So let's start with Ted with this one. What are your thoughts, Ted?
Yeah, so I guess I would make a distinction between a deductible and out-of-pocket damages. Nearly every state, I think, has either a law or a guidance suggesting that you try to collect your insurance deductible. However, when you're talking about out-of-pocket damages, I'm assuming you're talking about damages which there is no coverage for. That can get a little tricky because you can run into some issues there. It's my policy that I've developed over the years to not try to recover the insured's out-of-pocket uninsured loss, and there's a couple of reasons for that. Number one, it's usually not documented as well as their insured loss, and you can run into some credibility issues in proving your damages in the case overall. But probably more importantly, it opens some issues of potential conflict of interest. So that's another reason why I might avoid that. Some of the things that occur with a deductible interest is typically, and I would say at least for where I practice in the state of Ohio, technically, in order to collect somebody's out-of-pocket deductible, they need to be a party to the action. However, I can tell you in practice, if I make in a prayer and I pray for the insurance deductible, 99% of the time it's not an issue, and the court awards judgment for that. But there are occasions where if the insured is not a named party to the action, where a court may require you to either forego the claim for the deductible or file an amended complaint to add the insured as a party. And there's some pitfalls to doing that unless you actually have an agreement with the insured to represent them, particularly if they have other claims. Not sure if I missed anything, but that's sort of my initial thoughts on recovering extra damages for your client, for your insured. I would definitely make a distinction between the deductible and other claims.
Great, thanks, Ted. Mike, do you have any thoughts to add to that?
Sure. This is actually a quite difficult situation that the insurance companies are put in, because every state has adopted some form of the Unfair Claim Settlement Practices Act. And that act requires insurance companies to try to recover or make a demand for the deductible, and then they're generally required to reimburse the deductible out of any recovery they receive on a proportionate basis with the first party claimant. So the problem is that they have an obligation to try to recover it. They have an obligation to try to reimburse the insured, and most of the insurance contracts have similar language. It says something like, if we elect to pursue subrogation, then we're going to attempt to try to recover the deductible, and unless you specifically tell us not to. The problem is the courts don't quite understand that. So they usually look at that as, well, we're not going to let you recover somebody else's interest. And sometimes we can cure that with an assignment of interest, or sometimes we can cure that by making the insured an involuntary plaintiff. But it is quite difficult. And I think what I've seen is it really depends on court by court and state by state. I mean, I'm going to continue to make a claim for the deductible, and we try to argue that. And like Ted said, usually we're successful, but sometimes, there's just not a lot you can do. We can't guarantee that we're going to be able to recover the deductible in every situation.
Great points, gentlemen. Thank you for that. So let's try question 2. When does governmental tort immunity apply, and are there any exceptions? So, Ted, you want to take a stab at this one?
So I guess it's a broad question. As you should know from your civics class in high school, our government's split into different levels, right? We've got the federal government, you've got your state government, and then you've got your local government, your towns or villages, or your what they call usually political subdivisions. So as far as pursuing a claim against the federal government, those are going to fall under the Federal Tort Claims Act, and they have a specific claim form, an SF-95 form that needs to be submitted within, generally it's 2 years after the date of loss, and then there's a time period which runs based upon whether they accept or deny your claim. So if they deny your claim, your administrative claim, you generally have 6 months from the date of the denial letter to get your claim filed in federal court. So that's sort of just a broad on the federal torts. As far as claims against states and political subdivisions, In the state of Ohio, there's a specific Ohio Revised Code statute, 2744-05B, which precludes subrogation claims against states or the state of Ohio or any of their political subdivisions. So you're out of luck against the state of Ohio. You may have a claim against the federal government. I'm not sure if any other folks on the call have, to add to that, but that's the state of Ohio and the federal view.
So how about we have some perspectives from Mike and Ted? If you want to start, Mike, and then Tom, then you jump in after that.
Sure. Every state has basically tort claim notices, and every state, have tort claim acts that serves as waivers of sovereign immunity. And those statutes are all different, and they're all very limited. But the key thing is that you have to give notice. The notice has to be proper and sufficiently detailed, and it has to be given within a certain timeline. Some of the other things that we've seen are, each injured party or each damaged party has to give a separate notice. So for example, you may have to give a notice on behalf of the insured owner who has a claim, the carrier who has a claim, and the injured people who have a claim. Because if you don't do that, then you may not provide sufficient notice of the claim, and we're going to be sort of statutorily barred. Federal tort claims are really quite tricky, and state claims are equally difficult. One of the problems we see are you've got to identify who the correct agency is, and that's not always easy to do. I've seen situations where we're trying to sue a golf course, for example, and you would think of a golf course as an independent private company, but sometimes they're not. They're operated by park districts, and the park districts are operated by county governments. And if you don't follow through the chain of command and give notice to the right people, your claims are barred. And we've also seen that with transit authorities. Transit authorities are usually operated by local counties or local cities. So it's always important to try to look for, is this some affiliate or operation of a city, county, or state or federal government? And then if it is, there are limitations. So in Indiana, for example, the tort claim notice has to be given within 180 days. And then of course there are tort caps and other limitations. In Kentucky, for example, you have to give a tort claim notice within 90 days. And every state, sort of has other limitation and tort caps. But the key is to identify suits against potential government agencies very quickly and to get the notice out very quickly.
Yeah, and sorry, Tiffany, as Ted and Mike have kind of spoken to, each state kind of has their own take on the Tort Immunity Act, the Federal Tort Immunity Act. In Michigan, their statute is the Michigan Governmental Tort Immunity Act. And essentially this statute says that governmental agencies are generally immune from tort liability if they're engaged in or discharging the function of their agency. Essentially, anybody who is included in the agency, meaning its officers, employees, volunteers, or certain agents who are acting on behalf of the agency, are immune from tort liability if certain conditions are met. The employee or the agent has to be acting or at least reasonably believe that they are acting within the scope of his or her authority. That obviously changes based on the person, the individual. Is it an employee executing a job function? Is it a volunteer who's working on behalf of the agency? But they need to at least reasonably believe that they are acting within the scope of whatever it is they're doing for the government agency. The second condition, the agency has to be engaged in the exercise of a governmental function. So an employee who is having lunch is obviously not engaging their duty or doing their job. It wouldn't be considered to be functioning within the governmental duty. The third then condition would be for the employee or the agent to not have conduct that amounts to gross negligence. We typically think about this in the case of a motor vehicle accident. Was the employee grossly negligent in the operation of the vehicle? Were they driving recklessly? Were they not obeying speed limits? Things like that. And the second component of that is whether the gross negligence is the proximate cause of the ultimate injury or damage to property. If those three conditions are met and the employee is acting within the scope of their authority, doing the job that they are supposed to be doing for the agency, and they're not grossly negligent and are not the proximate cause of an injury, then in Michigan, you would not be able to bring a subrogation action against that governmental agency. The caveat here, and when things change and when they do open up to liability, is when that employee, agent, volunteer, whoever it is acting outside the scope of their job or their duty. I mentioned if a governmental employee is driving a truck and they're not doing a job, they're driving to get lunch, they're running a personal errand, they're done with their shift for the day and they're driving home from work. And the accident occurs in this situation, the argument can be made that that person is not acting within the scope of their authority, and when they're not, they then can become liable and no longer immune from tort liability. So in those situations, we could bring a claim, we could bring subrogation action against the governmental agency, and depending on the factual circumstances of the case, these claims could be successful.
Good point, Tom. And if you guys don't mind, I'll just kind of jump in a little bit here with my thoughts. So when we're applying it to our actual claims file, so just as Tom indicated, if we're talking about a motor vehicle accident, you want to obtain as much information in your initial statements as possible, or review those initial statements that were obtained by the underlying adjuster. So for example, when I drop my kids off at school every day, there's an officer who is in a patrol car who is has a uniform on, dropping his daughter off as well. That's clearly not within his scope of employment, but that's what he does. And so if he gets into an accident, there probably wouldn't be immunity. So, but if you had just the information that he was in a patrol car, he had on his patrol uniform, he could have already dropped the daughter off, but leaving the parking lot, it may appear as though he's within the scope of his job duties. So that's why it's very important to get the details if you can. But sometimes some of the information has to be pulled out during litigation and discovery, but it's important to review your initial notes from the underlying adjuster and the recorded statements that were made, obviously the police report, information like that, and if anyone actually reached out to the claimant driver. And then just as Mike and Ted said, you know, you want to look at your file to make sure that notice was provided. If notice was not provided by the underlying adjuster, get notice out or get over to attorney so that we can provide notice. So just make sure you're looking at your file to see those key things are met and see what you need to enhance your file, or what you need to hurry up and get over to your counsel so that they can enhance that file as well. So we can go ahead and move on to question 3. So what are the most common hurdles to bringing a subrogation action on a trucking claim? And so, not to shake things up too much, Mike, you want to start this one off?
Sure. Trucking claims, there are a couple different components of trucking claims, but my favorite type of claim is what I refer to as a cargo shift or cargo loss claim. And that's usually handled by a different department within the insurance carrier. And at least cargo claims are controlled by what I still refer to as the Carmack Amendment, which changed in 1995. It's part of the Interstate Commerce Commission Termination Act. And that's a law that basically preempts all state law claims against motor carriers for damaged interstate shipments. Those claims are awesome. I love those because it's strict liability against the motor carrier if they accept the load in good condition, the cargo was delivered in damaged condition, and then you just get approved the value of the loss. The damages are limited. We're kind of stuck in federal court for most claims, and the defenses are very, very limited. Usually what I see is somebody claims it's an act of God or there's fault by the shipper. The only thing to look out for, I suppose, is there are a few exceptions. The exceptions are these claims don't apply to household goods, live animals, perishable goods. We see perishable goods a lot, shipments of vegetables and whatnot all over the country, and then hazardous materials and international shipments. But I think the key is to recognize that this type of claim is a little bit different from an ordinary negligence claim. So the rules are different. You have to provide notice of the claim, be limited by contract anywhere between 9 months to 2 years. And I think what we see is you're looking for basically an interstate shipment and a bill of lading. The bill of lading is generally the contract that we're looking for. And if you see anything like that on a claim, sort of escalate it to either the right department or to the attorneys, because that's a nuanced claim. And then I do see some claims where people are trying to pursue the broker or the person who arranged for the shipping, and the federal law generally exempts the broker from any liability for whatever happens by the carrier. So I suppose the other type of claim would be, just when big rigs get in accidents. Ted, do you want to work on that one?
Yeah, so I mean, I guess if you're talking about a normal negligent motor vehicle accident type case involving a truck, some of the unique things that you might see outside of the ordinary issues is just trying to identify who owned the truck or who was driving the truck and what their motor vehicle carrier number was, right? So there are websites you can use to locate and identify the correct trucking company. You also can get into issues sometimes where, yes, I was driving a truck for this entity, but I was on a specific trip lease for another entity, and sometimes those are issues that you need to sort through. And those are questions you would ask in your initial interview if you get the chance to speak to the adverse party or adverse driver. And so those are the biggest issues I see on those types of claims, is just trying to identify the correct entity to pursue. And all interstate trucking companies are required to file with the U.S. Department of Transportation, and they have statutory agents, typically in almost any jurisdiction, to accept service and to accept claims filed against them. So I would make sure that I am tracking down the proper entity. I think that's the key element there.
Good point. It's good point. And so I just want to add in as well. So the Federal Motor Carrier Safety Administration does oversee commercial driver's licenses. And so if a driver that's driving a truck will be subject to that, they're required to adhere to certain requirements as far as mandatory drug testing, alcohol testing, things like that. And why that's important to you is, unlike a regular motor vehicle accident that's just involving two lay people in a commercial context, you may have way more information regarding previous violations, maybe substance abuse, things like that, drug abuse, that can go into help determining whether there was some sort of alcohol involved in this particular accident. So you will find in trucking cases, although they are more complex, you may have more documentation that could support and potentially hurt, but support your negligence action. So obviously try to get as much information as you can up front. And then once it goes over to counsel, our role would be to secure additional information in what's called discovery. So sending out information regarding those records that the employer is required to retain. So just wanted to add that. It adds a little bit more. And then one other point, when you have trucking accidents, a lot of times you will need an accident reconstructionist. So when you're assessing whether or not you want to bring your subrogation action, keep that in mind as an additional cost. So,
Well,
oh, go ahead, Mike.
I'm sorry, can I jump in? You brought up a good point about additional information. I think one of the things that we've seen is that almost every commercial carrier is running sort of advanced data logging equipment, and there's a lot of data available. Most of the carriers now have multiple cameras in use, definitely from the front. And if you're not obtaining that information as part of the workup of the file, it's certainly out there, and it's definitely a question to ask. And usually that video is pretty conclusive as to what happened. So, I think that the lesson there is to be aware that there's a lot more data available, especially camera footage. And if you look hard enough, I think we're going to find that there is video of the accident, and that's going to help establish liability.
Yeah, I just saw a video on social media the other day where it was a truck driver with a dash cam focusing in the cab, and he was, waving out the window, talking to somebody else, and seconds before just plowing in the back of another vehicle. So all that stuff is so prevalent now. You don't even necessarily need to get to the electronic data recorder, although that's also available. But yeah, you have the dash cams looking in the cab, the dash cams looking outside, front and back. So those are all things that you want to make sure you have in your file.
Good point, gentlemen. So let's go to question 4. How is ownership of a vehicle established when a vehicle is sold prior to the date of loss? So for this one, how about we have Tom take this one first?
Sure. In Michigan, this can be novel to some of the folks joining us from other states. In Michigan, we have a concept called constructive ownership. Essentially what it means is you can be an owner of a vehicle like we all understand an owner of a vehicle, someone who has purchased it, utilizes it regularly, and does with it what we all do with vehicles that we own. With a constructive owner, this is kind of a concept that's created under Michigan's No Fault Act. There's a section in it that defines owner, and it defines an owner as a person who is renting a motor vehicle or having the use of a motor vehicle under a lease or otherwise for a period that is greater than 30 days. The term of art there that leads to constructive ownership would be having the use of a motor vehicle. What does that mean? Well, essentially Michigan courts have defined it as meaning the use of a vehicle in a manner that comports with the concepts of ownership, which leads us to our next question. What does that mean? Concepts of ownership are again, what we think about when we think about what we do with the vehicles that we own. Possession. Are we exclusively utilizing the vehicle, or are we sharing it with other individuals? Obviously, exclusive possession tends to suggest ownership in that you are the only person who is showing a possessory utilization of the vehicle. If there's shared possession of the vehicle, then you have to ask if the individual we are trying to determine whether or not as an owner was using the vehicle permissively, or whether they were the person giving the permission for someone to utilize the vehicle. Once we answer those questions, we can kind of move towards the next component or the next concept of ownership, and that's the actual physical use. Questions we like to ask there are was the use possessory or proprietary? Are you using it regularly or sporadically, right? So if you are an owner of this vehicle, you would tend to be using it on a regular basis with the intent to continue to use it like that. It wouldn't be a one-off event where you access a vehicle one time, you don't have regular access or easy access to the vehicle, things like that. Michigan courts have found that when possession and use can be established, that suggests that a person is an owner of the vehicle, that person will be considered the owner of the vehicle from the inception of the lease or the sale arrangement that actually gave the person use of the vehicle. And that's regardless of whether the 30 days have passed. So how does this come into a situation where we see relatively frequently where there's a date of loss and there is a sale within 30 days prior to that date of loss? There's a person who sells the vehicle and the person who is utilizing the vehicle on the date of loss. We need to determine in that situation who the owner of the vehicle is. How a person shows that they are no longer the owner of the vehicle frequently comes into play in those situations. That's defined by the Michigan Vehicle Code. And essentially how that operates is a person who sells a vehicle in Michigan, completes a bona fide sale, is the term of art, of the vehicle, has to do one of two things to prove that they sold the vehicle and to therefore extinguish liability that would arise from the use of the vehicle after their sale. They can either accompany the purchaser of the vehicle to the Sorry?
No, I think that was just feedback. No, go ahead, Tom.
Okay. They can do one of two things. They can either accompany a person, the purchaser of the vehicle, to the Secretary of State and assure that that person takes the reassigned title and transfers it into their name. If that's not done, and that's typically where we see this in the cases that we deal with, the seller does not go with the person to the Secretary of State, doesn't make sure that the reassigned title was reassigned or even taken to the Secretary of State, and then there's the second side of this coin. If you don't take the secretary or take the title to the Secretary of State, you have to, as the seller, maintain a record of sale. Again, another term of art, essentially a record of sale in Michigan means a bill of sale. You have to maintain that document for not less than 18 months. So for at least 18 months after the date of sale. The bill of sale needs to include some specific information under the Michigan statute, and that's a copy or a photocopy of the reassigned title, and then a document that accompanies that includes the name, address, driver's license number, and signature of the person to whom the vehicle is sold, and the purchase price and date of sale of the vehicle. If a seller can do either of those things and prove that they did either of those things, their liability for any claim that would arise after the date of loss is essentially extinguished. If they can't, and oftentimes it's difficult to prove that you maintained a record of sale for 18 months, these cases become very, very factually dependent. What can someone testify to that they either did or didn't do with the original title? What can they testify to that they included on any record that they may or may not have kept? It's a very, very factual dependent kind of situation and can be very fluid. But those things are what we do in Michigan to establish who the owner of a vehicle is and how we assess claims that have that issue arising in them.
Good point, Tom. And I just want to piggyback on what you're saying. Excuse me. This is so important in Michigan because Michigan is an owner liability state. So when we are talking about a motor vehicle accident, obviously we have to meet the barrier of them being uninsured. But once we address that issue, we can sue not only the operator, so the tortfeasor, but also the owner of the vehicle. We don't have to show any negligent entrustment or anything like that. And then to go a step further in Michigan, for your uninsured claims, if any personal injury protection benefits were paid out, so also known as PIP benefits were paid out, you can sue the owner directly pursuant to MCL 500.3177. I say it every day, it just rolls off the tongue so nicely. But you can sue the owner of the uninsured vehicle, and you do not have to show fault. What does that mean for you? Your insured can be at fault for the accident, and if the carrier paid PIP benefits, the owner of the uninsured vehicle is still liable. And so sometimes those claims are missed. And so I just want to make sure everybody knows and tells a friend, and then that friend tells two more friends. That is some recovery we can get for you in Michigan. Now, you know, Ted and Mike, I want you guys to chime in and tell me what you think as far as your states and how ownership works.
Well, I'll go first just because it's a little probably quicker. So Ohio is not a owner liable state, vicarious liability. There's no statute. The only way in Ohio, there are ways to make an owner liable, but it's not going to be automatic liability. It'll have to be for negligent entrustment, where they've negligently entrusted a vehicle to someone they knew or should have known was unskilled or incompetent to drive a vehicle. Those can be difficult cases. You almost have to show that they were maybe out drinking with the person and they handed the keys to somebody that they knew was impaired at the time. So that's one way, negligent entrustment. Another way is agency, or having somebody a work relationship if the owner has someone driving on their behalf for an agency. So it's not really the ownership issue is not as vital because of the lack of vicarious liability in the state of Ohio. So Mike, I'll let you talk about your other states.
Yeah, usually we see this come up when you've got an uninsured driver, and usually the driver is a homeless person with no assets, isn't worth chasing, or maybe they're a career felon and they're in prison, and we're looking for other ways to try to squeeze some money out of a case. And sometimes we see, the carriers go after the owner, or we try to go after the owner, and really that comes back to permissive use statutes that Tom mentioned. Some states have a permissive use statute that basically says the vehicle owner is responsible for any damages caused by a person operating the vehicle if it's operated with that owner's express or implied permission. And the idea is that the insurance is going to follow the car in that situation. So we're trying to trigger insurance, or we're trying to sue an owner. Kentucky is a little bit weird in that it's a title state. So ownership's basically based on registration. So whoever the registered owner is responsible for insuring the car. So we generally have pretty good luck suing owners in Kentucky, but there are some exceptions. There's exceptions for dealers, and there's usually a 15 to 30 day grace period, for people to follow a sale, and then they can run over to the title agency and then re-register the car, and those claims can be a little difficult to pursue. But it's always worth, at least trying to trigger insurance. Send a letter to the owner and at least try to get their attention and say, hey, we think you're responsible for this. And then Indiana is just like Ohio. It's the Wild West. There are no statutes, but they generally follow contract rules.
Good. Thank you. Now let's try question 4. How do we assess the strengths and weaknesses of my subrogation claim, or how do I do that? So, Tom, what are your thoughts on this one?
Yeah, I think ultimately the answer here is get it to your attorney so that we can do the assessing. There's tons to consider in these cases. Things like credibility of witnesses, the extent of the documents that are necessary to prove our claims, whether those documents are all in order, and so on and so forth. These things are all can be pretty fact intensive. They can take a lot of work on our end to kind of develop the issues that we might discover within them. And that's what I mean, getting these files to your attorney so that they can get this review underway and make sure that they get the things that they need to kind of line up a successful litigation path, I think is critical.
Great, great. Does anyone else want to add a few thoughts to that as well?
Yeah, so I break it down in different categories, right? So you've got your liability issues. Do you have witnesses? Do you have physical evidence? Did you retain the evidence? Those are the type of liability questions you have. Is liability clear? Is it disputed? So I have liability, then you have damages. Do I have an excessively long rental bill? And why was that? Were we waiting on a part? Was it a unique kind of vehicle that had some extra value that you'd have to prove? So you've got damages, you've got liability, then finally you have collectability. So if there's insurance on the other side in a typical negligent state, not a no-fault state, then the question is, do you have sufficient coverage? Or other than an uninsured motorist, and then you have collectability issues, and what do we know about the person? Do they own property? Do they have a job that with wages that can be garnished? So I tend to break it down to those three categories. I know adjusters have to make a lot of decisions based upon police reports and maybe things that aren't fully developed. But just know that when it comes down to are we going to try the case, those facts will evolve as we get more information, as we actually talk to the people and understand whether they're a credible witness or not, and whether they're, what is the insured willing to participate in the trial. So there's all kinds of other things that can come into assessing strengths and weaknesses, and that evolves over time.
Thank you, Ted. And I like the categories, so I'm going to piggyback on what you said and also what Tom said. I'll add a fourth cost category, and I already told you what it is. It's cost. So when you're assessing your claim, you want to take into account what you're going to have to pay out, because obviously you want to decrease paying out something in order to get money back, right? But you may have to retain an expert. How much information or how much money you have to pay to obtain additional information. There may be additional costs with depositions, things like that. So assessing the claim, you absolutely want to look at the liability and the damages and the collectability, but how much is it going to cost you to even get a judgment, get a recovery? And that may affect your decision on whether you want to do what we offer, a letter campaign, where we may just send out letters, demand letters, do contact calls, things like that, versus send it over to litigation. So all of those things come into play. And sometimes you may need assistance from your counsel to make these determinations. And so that's why all of us on this webinar, we make ourselves available to all of our clients and let you know that we're here to help as far as assessing the claim, but also telling you potential costs that you may run into that you may not necessarily see that's going to happen later down in the litigation process. So we definitely encourage you, all of our clients that are here on this webinar, take advantage of that service that we have as well. And then Mike, did you want to add anything on this one as well?
No, I think I'm good. I think it's well covered. The key there is just to be a little bit flexible and to try to, keep your mind open and look outside the box, because sometimes there's a contract claim where you may be thinking tort, or, sometimes there are different people available that you can go after. So, and the situation changes a lot as litigation proceeds. So I think it's well covered.
Great, great. And so we are going to go to our sixth question. As a subrogation attorney, what keeps you up at night? So we'll start with you, Ted. Tell us your fears, your nightmares, all of those.
Well, other than the Cleveland Browns. So I guess the first category are statutes of limitation, right? Those are the biggest things that I worry about, and I understand the incentive to try to collect things in-house for as long as you can, but when we get a file in close to the statute, with days or just mere weeks before it runs, there's any of a number of things that can go wrong, right? So the number one thing would be statute of limitations and making sure we protect those at all costs. There's some other things, but as far as like trial goes, my biggest fear at a trial isn't whether or not we can prove whether or not we have a good case. It's whether or not the witnesses are going to actually appear, and whether they're going to say what they told me when we prepared, or whether it's going to be a different story. Because I think anybody who's tried some cases has nightmares. It sounds like a cop-out to say anything can happen once you're at trial, but it's not. Really, things happen, unforeseen things happen. So even in dead bang winner cases, there's always something that can go awry. So it's your biggest nightmare. I just attended a session not too long ago where an attorney was talking about they had prepared their witness thoroughly. They got up to trial. They handed them the document that explained all their damages. It was the only document that they relied on for damages. And they asked the witness, can you tell me what this document is? And their witness, for whatever reason, said, I've never seen this document in my life. So all kinds of weird things can happen at trial. That's why, when we say we prefer to resolve things, it's not because we don't want to go to trial. We're willing to do it, but there's always a little bit of safety in trying to resolve things if you can. But those are the two things that come to mind immediately for me.
Yeah, good point. Mike, what about you? Tell us your fears.
Well, I 100% agree with Ted. Probably at the top of my list is the statute of limitations. That's something that we're all very concerned with. I'm also, you never know what the insureds are going to say. And sometimes you just have to roll with it. I would say in addition to that, I think maybe it doesn't keep me up at night, but maybe something that bugs me on a regular basis is maybe a lack of records. So sometimes we get referrals that are maybe 125 pages, and it's just a big mess jumble of records. And what I like to see is what really helps me is a referral with contact information, identifying the insured, identifying the claimant, identifying the claims, identifying the damages, so that we're not, surfing around looking and hunting and trying to piece together what the file's about. I'd say the other part of that is, sometimes we don't get complete records. And if we assume that what we have is what we have, so excuse me, we put together the file based on what we know, but sometimes there are additional documents that come to the surface, and we're able to find either better supports for damages, or maybe even more potentially liable parties, or holy cow, I didn't know that. So we do need that. And then I guess the last thing, excuse me, sometimes it doesn't really bother me, but we get insufficient supports, like if, and maybe this is, if a file would come over a little earlier, we could get ahead of it. There's one of the things, there's a current social media trend on TikTok. And I don't want to give anybody any ideas right now, but it's called the Chromebook Challenge. And it's encouraging students all over the country right now to either stick a paper clip or a mechanical pencil to lead into the laptop ports, damage the battery, and cause a fire. So I don't want everybody to start surfing for that or try it at work, but it's happening all over the place. So sometimes in a situation like that, you'll have fire investigators and CFIs go in, and those guys are great, and ladies are great at finding the origin, but they're really terrible at finding the cause. They don't look at, okay, who did it? What caused the fire? So unless we have cause and origin, or really good witness statements, like I saw so-and-so do this, and stick that in the laptop, and we just don't have enough evidence to proceed with the case. So I think if we would have gotten involved a little bit earlier, at least with the documentation, we could have made sure that everything's there and we'd have a really good case to go forward. You know, the only other thing I think that bothers me is sort of piggybacking in the idea that we never really know what the insureds are going to say. Just because we may have a recorded statement from the insured, just because we may call the insured, you know, it doesn't mean that what they're going to say ultimately is it. I had a situation once where we're suing a contractor for dumping a load of rock and gravel at a work site. And when the contractor dumped the load of gravel at the work site, it caused the building collapse because it was arguably too close to the building and it was just a really bad idea. So we're all excited, we're gearing up for trial and we're almost ready for trial. And I start practicing with the insured and we tell the insured what we're doing, that we're suing the person and the company who dropped the rock at that location because they caused the building to collapse. And the insured tells me, he goes, oh no, you can't sue them. They didn't do anything wrong. I told them to put the rock there. And then I'm like, you know, so I suppose the frustrating thing is sometimes the lack of information, or maybe my fault not dotting the I's and crossing the T's early enough in the case to avoid doing all of that work. Are the things that really get on my nerves in the middle of the night.
Thank you, Mike. Tom, what about you?
Yeah, to echo both Ted and Mike, I think my biggest fear is the seemingly slam dunk case that devolves into a case that's going to turn on word versus word testimony. And I fear that because of what Ted and Mike have already gone over. When we get to trial and when we have insureds testify, you never can truly predict or control what is going to be said. And if you find yourself in a situation where it's the insured's word versus the defendant's word, there's only so much we can do, even as seasoned and very competent trial attorneys, to get an outcome that's favorable for our clients. And so that I think definitely is my biggest fear.
You know,
Okay, well, go ahead. No, go ahead.
So we see that a lot. We see what we call word versus word or 50-50 cases. And that doesn't mean that the outcome at trial is going to be 50-50. What happens is the judges and the juries, they assess credibility and believability based on likability, genuineness, authenticity. So even though you've got two cars that crash in the middle of an intersection and nobody saw the other car before the accident, it doesn't mean that you're going to get 50% at trial. It means the jury or the judge is going to believe one party or the other more likely than not. And sometimes if you're insured isn't very articulate or isn't very likable or isn't very presentable, you really don't have much of a chance. So that's my biggest fear. I've got lots of biggest fears.
That's a good point to add in, Mike. And another thing to remember to all the subrogation professionals, we are the plaintiff. So that means that we have the burden. So if the judge says, well, I think it's pretty much even, I don't know who to believe, we lose in those cases as well. But what keeps me up at night is the same thing that's keeping everybody up at night. Statute of limitations, especially in Michigan. There are so many different statute of limitations in Michigan for subrogation claims. We have parked cars that have a 1-year statute of limitations, but if they're uninsured, we may be able to sue them in 3 years. We have 3-year negligence statute of limitations, but then if it's PIP benefits is paid out against the owner, we have a 6-year statute of limitations. So that keeps me up at night all the time. And trials for sure keep me up at night as well. And I'm just going to briefly tell you the story of a very traumatic experience at trial. So I had a jury trial on a property damage case, and I had an expert. The case seemed to be strong, but the expert died before trial. And so what I had to do was read in the transcript of the deposition that we took, because we didn't have a video deposition. So the attorney on the other side was kind enough, because he probably realized that was fool's errand, to read it along with me. So he pretended to be the witness, and I was questioning him based on the deposition transcript. And when I tell you that expert testimony that is read to you via a transcript is the most boring thing you've ever encountered, I think the entire jury fell asleep. So that case did not go well. So when we tell you that trials are a gamble, they really are. And so you want to assess your case prior to trial, try to see if you can get a resolution, because the strongest cases, things can happen, insureds cannot show up. And just add another quick story, I had an insured the day of trial, came in and he told me that the guy who had hit him really didn't hit him, and he wasn't sure who the guy was. Come to find out they were friends. I didn't find that out until the day of trial. So I'm at trial and I found out that the two individuals, the insured and the claimant, were friends, and he changed his whole story at trial because he was trying to get his friend out of trouble. So you just never know. You just never know what's going to happen. So sometimes there is a need to push for a trial, but sometimes it may be best to resolve it for something reasonable, taking into account the huge risk of going to trial. Anybody else want to add anything to that?
I mean, I can tell you, I've had situations where I've actually spoken to our witness insured and prepared them, and then come day of trial, they disappear, they ghost you, and you're trying to get a hold of them, and you have no idea, and you have to either, you have to dismiss your case. So who knows what the person's motivation is, or if just something happened in their life, but it does happen, unfortunately.
It does. Well, thank you, everyone. So that does bring us to the conclusion of our presentation. Again, we wanted to talk about claims that aren't necessarily always touched in some of our other webinars, novel claims. So we touched on a few key areas. We hope that you pull some valuable bits that can help you with determining what cases to go forward with, what cases not. And again, the key is what you see on the screen now is get in contact with us. The best way is just to talk to us, and we can help you out with, assessing those novel claims, telling you things you need to consider, statute of limitations, always giving you advice on whether it's appropriate to go forward to trial or not. So we've provided all of our contact information. We're here for our clients to help you. And if you're interested in learning more about Weltman or becoming a client, we will definitely love to talk to you individuals as well. So I hope you have a great day. Happy Friday Eve to everyone. Bye.
Thanks, everybody.
Take care, everyone.